Welcome to the Alberta Independence Case channel. Today, we're talking about what may be the single biggest and most overlooked legal and political flaw in Alberta's independence movement. Not oil, not equalization, not Ottawa, but something far more fundamental: the failure to consult First Nations. And if that failure continues, this movement doesn't just struggle. It without any doubt collapses. Let's start with what just happened. A court has effectively paused the verification of the independence petition because of legal challenges brought forward by First Nations. Why? Because any move toward Alberta independence directly affects their rights. And those rights are not optional. They are constitutionally protected under Section 35 of the Constitution Act, 1982. This is not a minor technicality. This is foundational law. Section 35 recognizes and affirms existing Aboriginal and treaty rights. That means governments and even movements seeking to become governments have a duty to consult when decisions may impact those rights. This principle has been reinforced repeatedly by the Supreme Court of Canada. So when an independence movement pushes forward without consultation, it's not just politically risky, it is legally indefensible. Now let's talk about land. Because independence isn't an abstract idea, it's territorial. Alberta exists on land covered by Treaty 6, Treaty 7, and Treaty 8. These treaties were not signed with Alberta. They were signed with the Crown, and they predate Alberta itself, which was only created in 1905. That creates a serious legal question. On what land does an independent Alberta actually stand? Because those treaty relationships don't just disappear. They carry forward. And First Nations are not stakeholders in those agreements. They are rights holders. That distinction changes everything. Here's where the problem becomes unavoidable. Before gathering signatures, before launching a referendum push, before mobilizing supporters. And I would further argue that before amending the law that overrides Section 35 of the Constitution, there should have been consultation. Not as a courtesy, but as a constitutional obligation. Yet even after the court challenge, after the issue was made unmistakably clear, there has been no visible, meaningful shift toward engagement with First Nations leadership. That's not just a misstep. It signals either a misunderstanding of the law or a decision to ignore it, neither of which inspires confidence in a movement asking to form a new nation. Now let's move beyond the courts. Because even if you somehow navigate the legal barriers, you still face the political reality. Alberta is not a monolith. It is diverse. Filipino communities, African communities, South Asian communities, East Asian communities, Latin American communities, European communities, Chinese communities. Many of these communities include people who understand deeply the importance of historical justice, land rights, and inclusion. And here's the uncomfortable truth. If a movement appears willing to sideline First Nations, why would anyone else trust that they won't be sidelined next? That perception matters. Because independence isn't achieved by a narrow base. It requires broad, sustained, cross-cultural support. And right now, that coalition doesn't exist. Canada, as a country, is in the middle of an ongoing process of reconciliation. There have been national acknowledgements of past injustices, including the legacy of residential schools. Leaders like Justin Trudeau have formally apologized on behalf of the federal government. Institutions, policies, and public awareness have all shifted toward recognizing Indigenous rights. You don't have to agree with every aspect of that process to understand one thing: it has changed the political landscape. Any major political project that ignores this reality is operating in the past. and movements rooted in the past rarely succeed in shaping the future. So what does all of this mean for Alberta independence? It means the movement is facing a three-layered barrier. First, legal barrier. Without consultation, courts can and likely will block progress. Secondly, constitutional barrier. Treaty rights create obligations that don't vanish with independence rhetoric. Lastly, political barrier. Lack of inclusivity undermines public trust and broad support. That combination is not just a challenge, it's a dead end. So here's the question supporters of independence need to ask. Is this movement truly about building a viable, inclusive future? Or is it moving too fast, ignoring realities that cannot be ignored? Because independence isn't just about separating from Canada. It's about building something that can actually function legally, politically, and socially. And right now, the foundation isn't there. If this movement wants any chance of credibility, several things must happen. Genuine consultation with First Nations leadership, recognition of treaty realities, not avoidance of them, a clear legal framework addressing Indigenous sovereignty, and a broader, more inclusive political coalition. Without these, the movement doesn't evolve. It stalls. This isn't about whether independence is emotionally appealing or economically arguable. It's about whether it is legally possible and politically viable. And right now, without First Nations consultation, it is neither. If you found this breakdown helpful, don't forget to like, subscribe, and share your thoughts in the comments. And I'll see you in the next video.